Hey folks, Tripp Watson here with the Watson firm, and today we're going to be talking about non-competes. So if you're not familiar, in Alabama or in many states now, it's becoming increasingly popular for employers to put their employees under non-compete agreements. These agreements typically try to restrict the employee's ability to work in a competing profession or business or something like that, and they're designed to largely protect the employer's interest. But there's a few things that you need to remember about non-competes, regardless of whether you're an employer, an employee, or you're selling a business. There are several requirements that Alabama has. So first thing is Alabama by law says that non-compete agreements are void. So very first introductory issue, but that's not totally the rest of the story. So Alabama has a public policy that says that non-compete agreements are void until they're not. And basically what that means is that there are certain exceptions to the non-compete law that says that even though we consider non-competes to be unenforceable in the state, we will allow them for certain specific exceptions. And each one of those specific exceptions means that the person that wants to enforce the non-compete typically has to have some protectable interest that they are trying to protect under the non-compete. And as long as they are within one of these exceptions, then they can promote that protected purpose. Now, the truth of it is that at the end of the day, every single non-compete is going to be very fact-specific on whether or not it's enforceable. It's going to depend about whether or not you were employed at the time, how you were employed, what the circumstances surrounding your signing of the non-compete, whether or not there was additional consideration or additional payment for the non-compete. There are also provisions in the non-competes that even set that the provisions themselves, even though the non-compete itself may be enforceable, it may not be as enforceable as you might otherwise think. So you might say that something is subject to a 100-mile radius, whereas a court might say, that's a little bit too much. You're really only going to get about 10 miles. And it may not be for the full 3 years, but it may be for a year. The bottom line is that it's very difficult on the front end to say exactly how and whether or not a non-compete is going to be enforced and the extent to which a non-compete will be enforced. So a lot of that is just basically to boil down this. Signing a non-compete in the state of Alabama is testy. If you're an employee or if you're somebody that's going to be signing a non-compete, do not sign a non-compete unless you are perfectly acceptable or completely acceptable of the terms that are set forth in the non-compete. You do not want to try and find a loophole in an existing non-compete if you're subject to a non-compete. It's honestly a luck of the draw on which judge that you end up getting, whether or not they'll even enforce the agreement or how much they'll enforce it. And a lot of these have high risk scenarios that a lot of the non-compete agreements will have attorneys fee shifting. So even though you might be only partially successful in getting the non-compete set aside, if they are at all successful, they might still be able to hit you with attorney's fees for them having to prosecute it. On the other side of the scale, if you're an employer, always talk to an attorney before you draft up a non-compete. The language of the non-compete becomes very, very critical, and if you're trying to enforce a non-compete against somebody else, you're going to carry a much higher burden than a traditional plaintiff would in a lawsuit, because you're going to have to show a number of elements and prove every single one of them. And if your contract is lacking for the amount of information that's necessary, then a court may find that the non-compete is not enforceable. So it's critical that you speak to an attorney. But I'll leave you with this. Regardless of which side that you're on, do not have a non-compete that's out there that hasn't been reviewed by an attorney. Every single non-compete that's out there is going to be subject to a very fact-based inquiry, and so you've got to know what you're getting into before you ever sign it, because once you sign it, you cannot gamble that it may not be enforceable. Even though Alabama law does say that non-competes are void as a matter of law, there are numerous exceptions, and courts will often enforce a non-compete that might otherwise be unenforceable in another jurisdiction. So if you are an employee or an employer that does have a non-compete copy that you would like to look over, we're happy to do that. You can contact us. Our contact information can be found down at the bottom of the video, or you can feel free to give us a call at 205-545-7278. Again, my name is Tripp Watson with the Watson Firm, and y'all have a great day.